Well, the state has ruled that strippers are not artists and lap dancing is not art, and clubs do indeed have to pay sales tax. We're joined by WGY legal analyst Paul Harding of Martin Harding and Mazzotti. Good morning, Paul.
Good morning.
Hey,
Good
Paul.
morning, guys.
So this ruling in the Court of Appeals was 4-3. I'm surprised it was that close.
Well, it was spicy decision. Yeah, the opinions don't normally read this way. What happened was, again, just the briefest summary there, that the court came down and agreed with the appellate division that these lap dances were not dramatic or musical performances, and therefore didn't qualify for what happens on Broadway or what happens in other what they were defining as highbrow events. Well, a group of judges, three out of the seven that chimed in on this said, we don't like this. We think that what they're doing is they're taking a look and they're deciding based on taste, meaning I don't like lap dances either. We think that this is not the way to go, but we shouldn't put an unfair tax on this. And if it seems to be a highbrow event, then we're going to exempt it. If it seems to be something that we don't agree with, then we're not going to tax it. So, yeah, it was a surprise.
So, it's kind of tricky. It's almost like they're trying to decide, and correct me if I'm wrong, what is art and what's not.
Right, and they have some ability to do that. And the example that Judge Smith said, he said, I don't read Hustler magazine. I prefer to read the New Yorker, but I would be appalled if there was a separate tax for Hustler magazine than there was for the New Yorker. So, yeah, this 4-3 decision really opens the door as to whether or not they're going to attempt to take this to the Supreme Court of the United States.
Well, the opposing argument and the example that they used was, well, if you see ice dancers performing or figure skaters performing and they are subject to the tax, then certainly something like this would also be.
Yeah, it's hard to go, that's the one that maybe feels like it's on the fence, right? You got some ice dancers and they're out there, they have a perfectly choreographed event, and that's taxable. So, yeah, no one was surprised that the decision favored the appellate division decision and confirmed that this is a taxable event. The surprise was, as you pointed out so early in this discussion, that it was a 4-3 decision.
Yeah. So why is ballet so different than ballet on ice? That's what I don't understand.
That's
really
the argument I'd rather be making in front of the Court of Appeals than that. Yeah.
So do you think this is going to be appealed upward? Could it actually end up at some point with the U.S. Supreme Court, or at least an attempt?
Boy, it's so expensive to get up there, and they're so selective as to what cases they take. There would have to be an interest group, somebody outside of, I think, the folks here who have brought it this far, who've decided that this is such a strong constitutional argument, they want to support it. Meaning, it would be $1 million plus to do what it takes to even present it to the Supreme Court, and then the Supreme Court would have to decide if they want to hear it. They take about 3 or 4% of the cases that they have in front of them. So we'll wait and see if somebody steps up and is offended by this argument. The fact that it's 4-3, in my opinion, I think there are people waking up this morning across the country who may take a strong view of this and may want to support this thing moving forward.
And Chuck's biggest concern, is if they do have to tax these lap dances, that they're going to raise the prices, and he's just going to have to pay the ultimate price.
It's an outrage.
Yeah, there's a whole fallout if this thing goes down that way.
So it does have a broader impact.
It's bad for the economy. That's what I'm saying. Thanks, Paul.
WGY legal analyst Paul
Thanks.
Harding of Martin Harding and Mazzotti. 1-800-LAW-1010. Thanks, Paul.